Thank you, Jacob. Good evening, Mayor, Council. Tonight is our charter review meeting for sections 19 through 25. It will be presented by Cliff Shepard. You should have all received a package emailed to you at the end of last week with the information for tonight. And with that, I will turn the floor over to Cliff.
All right, thank you, Mike. Let me get the share screen function in operation here, and off we will go. All right. Of course, they would put that gallery right where I need to scroll. So let me move that over so I can see what I need to see. All right, so as you know, we're starting on section 19, nominations. And by the way, I'm trying to get better at this as we go through. And so when things are not of a substantive nature, unless anyone objects, I'm just going to cut to the chase and say most of the changes were either gender neutrality, clarification, nothing substantive specifically, at least in this first section of changes. The substantive stuff comes a little bit later when we talk about the amount of filing fee, and we tried to convert that to what is current with the help of the city clerk or acting city clerk, Ms. Gossett. And so that's what we have here. Again, I'll skip over the gender neutrality and punctuation kinds of stuff. As to the filing fee, the underlined language there represents the consistent with what is currently the case, a filing fee and an election assessment. The filing fee is 3% of the annual salary of the office. The amount of the election assessment is 1%. That's set by the state. We've crossed through the numbers that are obsolete. And there's a memo from Ms. Goslin. I said Gossett. I meant to say Sherry Goslin. There's a memo from Ms. Goslin that supports that information. And so that's the only thing that adds any substance to this provision. And of course, as always, the section about how it would read with changes. Does anyone have any questions?
I don't have questions, but I do have a comment. Since right where you are, this is the form where you ask for signatures. We, the undersigned 10 electors and residents of District Blank. That doesn't work for at-large and mayor.
That, by the way, was no change. It's as you can see, that's taken straight from the current existing form. And I don't know how that is implemented by candidate. It is my assumption. You're making a point that's valid, by the way. I'll explain that in a minute. But it is my assumption that if you're in one of those at-large or mayoral seats, you simply would leave the district thing blank, or perhaps write in the word all. But I don't know how it's used, but this is the form that came out of a charter, and the clerk did not suggest changes to it. And so I assume that there had been adaptations made. But if there needs to be something or two different forms or whatever, that's certainly something we can accommodate.
I just think it could be a little confusing for somebody running first time for an at-large seat. They might think that you have to get all people in one district or have one form for each district.
Mm-hmm. Again, that's for you all to let me know if you want me to make a change of that nature. That's an easy one to fix.
Not seeing any hands raised, Cliff.
Okay.
We'll continue to just cross it out.
Yeah, you cross it out, or you can, again, I think all works. Crossing it out works. Writing the words at large also works. So there's a number of ways, and I presume that one or more of those ways is what has been going on, but I don't know that. So that was just my assumption. So
yeah, just to clean it up, but apparently okay. No. I'm a district person, so I actually need that little line. So if the at-large people are perfectly fine with it, then that's fine with me.
Okay.
The other one is lower underneath the office of councilperson 200.
Here? Oh, you mean this under the fees? Okay, let me
yes.
Back. Okay, yes.
Okay. Any candidate may withdraw his or her nomination not later than the last day for filing nomination papers by filing a notice to withdraw with the city clerk. does that have to be in by does the withdrawal have to be in by noon, which is when the nomination stuff does, or can the withdrawal be done by 5 p.m., the close of business? Because there's a 5-hour gap or a 4.5-hour gap between when you file and when you can withdraw. So if I want to be shady, I'm going to be
Mhm.
shady. I would have my papers submitted, and I would have somebody I know submit their paperwork, and nobody wants to get into a 2-person race. And that happens by noon. And then at 1 o'clock, I withdraw my name. So the other person is the only name on the ballot.
So you're suggesting that candidates would,
If you're going to withdraw, you have to do so before noon on the last day.
but I'm shocked that you think that candidates would manipulate the process.
I'm a political scientist.
Okay. Yeah, again, you're right that it's not clear. I actually hadn't even thought about that as a need for clarification, but this is an easy change to make. Not later than the same date and time for filing the nomination papers, if that changes, for example, from noon to close of business or whatever. So there's a number of ways to fix the issue if the consensus is it needs fixing. Just give me some direction and I will make that change.
And I see we have Councilor Stokes' hand raised.
Sorry, I'm on my iPad. It's a little tricky. I was trying to read the section 19 a little bit more closely to respond to Councilmember Georgette's comment about the residents of districts, since I am an at-large person. And I was wondering if there's a way to I was trying to think if we could put an and or residents of district, but I don't think that works. If there was some way to distinguish that, because I think I asked the city clerk and I just put like NA on there or something, like not available or not applicable for the district portion. But I was wondering if there was something, because to Councilmember Dumont's point, as a first time at large member, I believe I was confused. And I believe that is one of the questions that I asked the clerk when I first got the form and read it was, wait a minute, I'm not running for a district seat. Do I have to have 10 signatures from my district? Okay, no, then what do I put in this district blank? And I think I probably just put NA. But I was wondering if there's like an and or something in there to help clean it up, because I think Councilmember Dumont has a good point since we're reviewing it.
Well, certainly the answer is yes, you can clean it up. You could do it in a number of ways. For example, we the undersigned 10 electors and residents of the blank, or residents of the city of Jacksonville Beach, pair in for at-large office or something like that. And other ways I could think of that are not on the fly. So what I would probably do here is get with your clerk, who interfaces, I guess, directly with Duval County, and see what they think will make it the clearest to them what's going on. But I really don't understand that there's been a confusion except at the candidate level. But nevertheless, I have no problem with coming up with language that will give you option 1 if you're in a district, or option 2 if you're at large. That's an easy thing to provide for if that's the consensus of what you want to do.
Councilor Golding.
Going back to Ms. Dumont's comment about the clarification regarding the withdrawal, I think we do need to make sure that we have clarity there, and that the withdrawal needs to be done by the deadline that the filing deadline is. So however we can word that, I think that needs to be clarified.
I can put that in by simply saying the deadline for filing nominations, nomination paper. So it would then read, not later than the deadline for filing nomination papers. And that way, whatever that time of day is, whether it's at noon, 1, 2, 3, or 5, you'd be covered. And then they would coincide with one another. Now, I will say this, and I want to throw that out there for your consideration. Let's suppose that we go through the qualification process, and I don't do my withdrawal by that time, so that according to this, my name will appear on the ballot. It may be that is my desire in order to create chaos, because one of the situations we find state right now, because of the way our state election law works, is candidates are recruited to have their name on the ballot that will never campaign, but will be in a situation which has the opportunity to split some other candidate's vote away from them, and give one candidate or another an advantage. A certain state senator from South Florida, and it somehow seems like it's always South Florida, did this, and it's now being prosecuted, along with a candidate that he chose to pay money. I think it was like 50 grand was the allegation, to have a name on the ballot as a ghost candidate, if you will. And so, you understand that when you leave the name on the ballot, that's not necessarily a win either, depending on the circumstances. But again, the clarification is not the issue. The ill intent of the actor is the issue.
Not seeing any other hands raised, Cliff.
Okay. Well, if I understand correctly, the deadline for filing nomination papers issue, we will change that to make that clear on the timing. But in terms of the other thing regarding the at-large or not at-large district thing, do I make the change or not make that change?
I don't need the change made. I've only run at large, and we just put NA in that blank. So as long as the clerk and the candidate are on the same page with that, I don't think that is warrants clarification at the charter level.
Okay. All right. Anything else before we move on? All right. All right. We're going to scroll down to section 20. All right. There we go. All right. This one had no substance change really either. These were the issues there were a couple of punctuations and a redundancy per the memo from Ms. Goslin. And so I'll be happy to explain anything that needs explaining, but I think it's fairly self-explanatory. Are there any questions or concerns in section 20? I'm not seeing hands. Mike, are you seeing any? All right, then I will move forward. The next two sections were vacant. And so unless somebody wants to create something, which by the way, I will mention for the sake of discussion, that is something you can always, just because I have a memo that covers the section so that we make sure we go through them all, doesn't mean that any of you, or for that matter, a member of the public can't bring something forward it wishes us to consider to add to the chapter. So the appearance of these vacant sections is just a kind of a reminder that if something comes across your desk or in your inbox that says, hey, maybe we should have something that says this or does that, this is, that you certainly have the ability to raise things that are well beyond what is in my memo. That said, the next section that has substance is 23. And then after that, 24, and both of them, at least from our office, came with no changes recommended. Actually, 23, 24, and 25, we had no changes recommended, but are open to discussions as to our conclusion as to why none were required on any of those sections or consideration of what changes you might like.
Councilor Golding?
In section 24, there is a his in the first sentence, so that needs to be changed for gender neutrality.
Where did section 24? I missed it. Aha, I missed it. Okay, my bad. I will circle that and certainly fix it. All right, my bad. All right, no problem.
Counselor Dumont?
Thank you. So 23 refers to 25, and in 25, it says recall or removal from office any elected official of the city as provided by general law. By general law, I take it you mean state law?
Yeah, Florida statutes, and it can be the statutes or Florida Administrative Code, yes.
And what is the current statute? Because
Okay.
I thought it was very difficult to remove a local official
It
through a
is.
recall or removal, like
It is.
impossible.
It's not impossible. It's difficult. It's supposed to be difficult. I'll explain the whys, and then you can debate the policy. But first, let me tell you what the grounds are. I believe there's 7. Most of them would be considered antiquated based on the way they read. The 2 that are operative 99% of the time are misfeasance or malfeasance. Many people don't know the difference. Others are public drunkenness, incompetence. That generally means that they are mentally unfit or either physically unable because maybe they're in a vegetative coma or physical coma, something like that, and things of those natures. But the 2 that get to play, the ones that actually get utilized, are misfeasance and malfeasance. So what is the difference between the 2? Misfeasance is essentially negligence in the performance of your duties as an elected official, and it's pretty broad. It is also difficult because all of the recalls have to be able to withstand, if challenged, the petitions, scrutiny that they state a legal grounds. And disagreement with somebody's vote is not a misfeasance situation, although often voters who are upset about something could make that argument. So misfeasance actually properly applied is when it's not just the decision that's disagreed with, but that there is a misapprehension or misunderstanding that amounts to negligence in the performance of an official duty that would cause voters to have concern about someone's competence to serve. An example, and I don't intend to do this to take a side of a political argument, but a recent member of elected office with whom we were all familiar thought that Puerto Rico wasn't a part of the United States. So that you could argue was negligence, maybe suitable for removal, at least under Florida's recall statute. So, if you don't know the states and territories of the country you govern, that could be arguably a problem. Now, in terms of malfeasance is different. Malfeasance is if you actually do something that would be considered a violation of law while in office. That can be anything from a violation of the charter. It can be being arrested for intoxication or drugs or any kind of a crime. Typically, it relates to your performance in office. So a violation of sunshine, a violation of public records, and those kinds of things. But if you are talking about the difference between the 2, the misfeasance standard is a negligent standard. The malfeasance standard is a violation of law standard. And it's literally any law. It could be a local ordinance. Now, what happens in the recall process is that the petitioners, the citizens, it's led by the citizens, not by the internal government, would have to get together, and I think the number is 25%. I can refresh my memory on that, but get signatures from at least a certain percentage of voters to say that the official so-and-so should be recalled based on misfeasance or malfeasance, sometimes both, in office in that they did blank or they failed to do blank. And once those signatures are attained, then they are sent to the supervisor of elections to certify that they are all of registered voter status within the city. And then, again, assuming they are unchallenged, once the magic number is met, then the recall is certified to go on the ballot, and it will essentially read, shall fill in the blank person be recalled from office. And if that's going to result in more than a majority of, or at least a majority of council, if it's more than one, then they have to have a slate of officers who will take the place of those who are potentially being recalled in the recall election. So that's how the process works. The interim step that happens between certification of the number on the petition and the actual recall election is where a challenge could occur. So if I'm the official who is sought to be recalled, and I think the petition states an invalid reason, they're questioning whether they would agree with my judgment, but not that I was negligent or that I was violating the law, and it's insufficient, it states insufficient grounds, then I can take that to court to challenge. However, and this is very interesting because this is where the elected official may think it's unfair, but it is what it is. You're not there in that proceeding to prove that the statement is true or false. That statement is to be proven by the voters. The way the law reads is the voters, in deciding whether to recall or not recall the official, are the ultimate jurors. The only thing the judge is deciding is whether the petition on its face gives sufficient grounds to fall into one of the several grounds for recall. And again, we focus on malfeasance and misfeasance because those are the ones that get cited. You rarely have someone who is a, quote, public drunkard being removed from office for that reason. And of course, there's all kinds of other issues out there regarding protection of people with disabilities, and alcoholism is now considered a disability and those kinds of things. But the misfeasance, malfeasance gets a lot of play. If the petition on its face states a valid basis for recall, even if the candidate, or in this case, the elected official, believes that it's untrue, that's not what the court's deciding. The court decides only, is the petition sufficient on its face with grounds? Then, if that's the case, it goes to the electorate by recall vote to vote the person in or out based on the allegations in the petition. So, importantly, it does not mean, based on the outcome of the vote, as you can imagine, since there's no court proceeding per se, that candidate is guilty of any of those things. It just means that in the opinions of the voters, that candidate is guilty of those things, and that's sufficient to get them removed from office. So that's how it works. Now, you asked a relevant question, Ms. Dumont, and that is, I understand it's really difficult to do recall. Why is it difficult, and shouldn't it be easier? Well, under the constitutional law of all of the 50 states and its territories, candidates, once elected to the office, are considered to have a property right in that office. So it is a constitutionally protected property right, just like protection of your own private property. And so you're entitled to due process of law, you're entitled to a number of other things. And so the recall statute, as provisions of it are, not easy to attain, but they are attainable and people do get recalled. But that's because of the requirement of a protection of that property rights interest for elected officials. You may not have thought of that you have a right, quote unquote, to that office once elected, but according to the Constitution and the Supreme Court who interprets it, you do. And so in order for you to be removed from that office, there are procedures that have to be met, and that's where the recall factors in. And that's why they have the protections that are built in, including the ability of the recalled official to challenge the sufficiency of the petition before it's voted on. So that's how it works. Again, I don't ask you to agree with it. That's just what the way law is. If you want a different standard for recall, so long as it gives due process, gives the official opportunity to defend themselves and notice and those kinds of things, I suppose you could come up with one. Certainly we haven't done that here. It would take some time, but I could try to come up with something for you.
Oh, no, I just wanted to make sure that this state does have a way to
Yes.
Remove people, even if it's very narrow. So thank you.
Well, it's wholly unsatisfying to many council members and councils, including many that I have, not many, but at least 3, where somebody on the council really screws up. I mean, think along the lines of the former city attorney. It's so embarrassing to people. You want to be able to take action and show that this is not something that you endorse or tolerate, and yet your hands are tied. But in fact, the matter is, that is the way it is. It is the way it is on most every government, not all. And where it's not, that in itself has its own problems, because if you're going to be the judge, jury, and executioner as co-elected officials with the same right to the office as the other person, when it's only one, you can say, well, okay, that'll be fine. But when it's more than one, then you get a little hairy, because, okay, well, we always have these 3-2 votes. Why are we trying to get rid of the 2 that are always the minority? Because they're irritating the crap out of us. And you can see how quickly a process that was supposed to not be political can become political, or at least arguably seem political, which is why defaulting to the state statute is, generally speaking, I think the wise way to go, but you're not required to do that. Any further questions on recall? Any questions on anything else?
Councilmember Meza.
Yes, Mr. Cliff, I have a question on 23 on the vacancies. Does that apply to someone, let's say, for example, is running unopposed, the person in office is termed out, and the person that's running for that seat, let's say they get in trouble or, God forbid, they pass away. Does Section 23 apply to that too as well?
So if I understand you correctly, the person who is in office will be concluding their term at some point post the current election, when a new candidate would either be elected by default because there's no one else running against that person, or when the election is ongoing, but one candidate maybe drops out, leaving it unopposed, and then the one remaining candidate has a problem. They drop dead, they get arrested for a crime, they decide to drop out for, some skeletons have come out of the closet, that sort of thing. Where does that leave you? And it's after qualifying is closed. Is that the question?
Yes, that is the
Okay.
question.
That is a vacancy that would occur, but it would not occur at that moment, because again, the person who is in office, who is being termed out, is still there until the new person can take office. So what would happen is those 5 or 7, depending on the size of the council, would then, per this provision, be able to appoint the person to fill, and in this case, for the next year, I guess, until the next regular municipal election. So yes, in that unique set of circumstances, you would have a situation where the 5 or 7 remaining council people would appoint the successor to the one who's going to leave council to fill in for the next year until the next regular election. It's a rarity that it could occur, but it obviously could occur, and that's how it would be done. And again, it's because the office being vacated is not vacated yet. It's not vacated until the new person would take, and that person isn't able to take. So now you have a vacancy created and you fill it.
Okay, thank you.
Is there anything else?
On this topic. Councilor Golding.
So Cliff, just to
Mhm.
follow up on your answer to Councilor Meza, you said that someone would be appointed to fill that position until the next year at the
Mhm.
general election. In our case, we wouldn't have an election until 2 years.
Well, it says next regular municipal election. So in most of the governments I serve, that is an annual event for somebody's office or the other. But yeah, that would be whenever the next regular municipal election is. If it's your case is 2 years, then yeah, that's what it would be. It's whenever. I assumed, my mistake, that it would be annual. Most of the cities that we have are on staggered terms. So literally every year somebody's up for election. Sometimes it's
Okay.
more than one.
I just wanted to make sure I understood. Thank you.
Mm-hmm. That's what it would be. So if you fall in that gap between the end of closing, end of qualification, but before the election has occurred, or even in the case of, let's suppose the election has occurred, but the person hasn't been sworn in and taken office yet, and they, are killed or have or die, something happens, or they just say, you know what, never mind. You have the vacancy, the same circumstance. The vacancy's there, and this provision is how you fill it. Anything else?
I see no other hands raised.
Fantastic. Well, folks, it's been a pleasure. I hope they're always this easy. Are we ready to conclude, Michael?
I believe we are.
All right, I'll turn off my screen share. And unless anybody's got anything else, I'm going to hit the leave button.
Okay, so Mayor and Council, this wraps up our charter review for this evening. Just a reminder that you do have on the calendar an in-person meeting on Thursday. It will be a city council workshop, 6 o'clock in the council chambers. to discuss direction for the CRA. And also on Wednesday, we do have an employee luncheon occurring from 11:30 to 1:30 at the exhibit hall over at Sunshine Park. So we look forward to seeing you all there. And then, of course, we do have the budget showcase financial condition report occurring on Friday as well. So we'll be seeing a lot of each other this week. Everybody have a good rest of the night, and we'll see you a little bit later on. Bye-bye.
Good night. Good evening, all. Thank
Good
you.
night.
Bye-bye.
Thanks, Cliff.
All right. Adios.